Good morning. Though there are multiple cases already decided about granting anticipatory bail in respect of offences registered under Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 33 of 1989. At present, on 23/8/2024, Supreme Court has given new, new ruling in respect of the said provisions of the Act, Section 18, which prohibits grant of anticipatory. They say uh, uh, the Supreme Court has held that the Act was enacted to improve social and economic condition of the vulnerable section of the society, as they have been historically subjected to various indignities, humiliations and harassment, besides deprivation of life and property on account of their caste identity. This legislation thus intend to punish the acts committed against the vulnerable section of society for the reason that they belong to particular community. Then second ratio was that the bar under section 18 is not absolute bar. Section 18 of the said act, SC/ST Atrocities Act, would apply only those cases where prima facie material exists pointing towards commission of an offence. Then third one, they say what is prima facie? What is prima facie? So they have given deep discussion about by going through the dictionaries. They say prima facie is a Latin term that translates to a at first sight, or based on first impression. The expression where no prima facie material exists warranting arrest in commission of FIR should be understood as when based on first impression no offence is made out as shown in the FIR or the complaint, that the they say that by bare reading the complaint, if no offence is made out under said act, that is, they say, prima facie existing when no prima facie is existing. Then say question of 3(1)(r). Question of 3(1)(r) was discussed rightly, read with section 7(1) of Protection of Civil Rights. They say the intention of the accused to subject the concerned person to caste-based humiliation. Therefore, they say historically entrenched ideas like superiority of the upper caste over the lower caste, untouchable, the notions of purity and pollution, etc., that it could be said to be an insult or intimidation of type envisaged by the Act. Mere knowledge of the fact that victim is a member of scheduled caste is not sufficient to attract section 3(1)(r) of the Act. Then finally, they say the refusal to grant anticipatory bail is set aside when the special court refused to grant anticipatory bail and when the High Court division bench on appeal. So if the anticipatory bail is dismissed or bail is dismissed under SC/ST Atrocities Act, you have to prefer appeal. That is called special appeal. The division bench has rejected it. Supreme Court has said, therefore they have set aside both the orders and granted anticipatory bail, because the facts are like that. When they draft complaint, they are not properly applying their mind. Therefore, the allegation in the complaint was that the Sajan Sakaria, a YouTube online magazine runner, seems to have circulated certain news about this complainant, the particular MLA who was elected from the reserved constituency. He simply says he is defaming me, he is tarnishing my image, giving false information and confusing the video viewers and that. and his allegation is that I am belonging to scheduled caste. That is not sufficient. Therefore, Supreme Court has granted anticipatory bail. Kindly go through the judgment. It will be far better while you are drafting the complaint, and it is far better when you are seeking for anticipatory bail. Best wishes.